So when Greg and I were preparing for today's talk, I went back through our notes, and this is our 5th consecutive litigation update for the section. And every single year when we're walking back to our office after it's done, we always kind of ponder, like, you think they're really going to invite us back next year? And I think it's really kind of a, sometimes this lecture kind of hits on all the potential pitfalls that a transactional attorney who spent 2 hours on a deed 10 years ago, and little did they realize it was going to end up in litigation, end up all the way up to the appellate courts, and be some seminal decision about what got actually conveyed, etc. And so, but it's a good refresher. We, going into it, there's some areas that we don't talk about. And for those of you who this is your first time at one of our updates, we don't tend to talk about foreclosure law. That is a pretty dynamic area statutorily, and it's just hard to keep up with, and I think that could be a separate seminar in and of itself. I do have a couple non-judicial foreclosure cases that were published by the Supreme Court this year, and so we will talk about them. We also will hit on a couple national things that we're watching on the national scheme, because a lot of land use topics tend to cross courts and statutory regimes, and appellate decisions deriving therefrom tend to be kind of similar across the country. And so there's a couple land use and inverse condemnation regulatory taking type cases which we've included in our materials. Finally, this is just Greg. Greg and I have clients, and we represent them in courts. And this is Greg and Mark's personal opinion about the state of the law, and giving you an update on what we think the courts meant and how we think it applies. Reserving all rights to change our mind in a motion for summary judgment. Okay, without further ado, Greg Kugle.
That's right. Nothing said here is an admission in any case I'm working on. Let me start again by thanking everybody for having us back. And if you can see behind me, I have crutches, and I was explaining to a few people, I don't even have a good story. I fell off of a retaining wall at my house, so I can't sue anybody, and broke my heel last week. But that's an important segue into the first case I'll talk about, because I could have fallen off a seawall down at the Gold Coast, and the result might have been different.
Well, you still have a sore foot.
And I wouldn't. No, I may have fallen in the ocean and wouldn't have broken my foot. And that kind of a question would have been decided under an old Hawaii Supreme Court case called Kimball versus Levy, which was much talked about in the very recent Hawaii Supreme Court decision, which we all call the Gold Coast case, but which was really Gold Coast Neighborhood Association versus State of Hawaii. And I would mention that if you haven't read the opinion, and I'll talk about it, but it's a Justice Pollack decision in which Justice McKenna and also Judge Castagnetti were in the majority, and then you had Chief Justice Rechtenwald joining in the dissent, which was written by Justice Nakayama. And Mark and I were commenting, there's been a few cases recently where you can sometimes see there are not unanimous decisions, and sometimes, and this might be one that's indicative of some level of a split between the minority and the majority, and sometimes you see Rechtenwald and Nakayama, sometimes with McKenna joining, sometimes she's on the other side. So, I don't know what that portends to the future, and I sure haven't tried to figure out which kind of cases those occur in, or where philosophically they diverge. But let me just tell you about the case first of all. I'm sure most people, if you've ever been to the beach down at the Gold Coast end of Waikiki past Kapiolani Park, you'd be familiar with the large seawall that fronts about 11 properties down there, condos and co-ops, which we call the Gold Coast. As the case makes clear, that wall was built by unknown parties, private parties, not the government, in the 1930s, Undisputed Facts. That was the interesting thing about this case. It was on largely by stipulation between the state and the association, which was a group of the actual condominium owner associations for those various projects down there. So the seawall had been built in the 1930s, had been in place for 80 years, and for most of that time period has been used both by residents and the general public to traverse along the coastline as well as to access the ocean for surfing, fishing, ocean recreation, etc. All that was completely undisputed. Also, what was undisputed was that between the 1980s and the 1990s, the state of Hawaii had procured money and engaged in maintenance and repair of that seawall on multiple instances. Also, from 1975 to the present, in a lot of official government records, such as environmental assessments and other things, the state had acknowledged that it had repaired and maintained the wall over those years. All well and good. The problem arose in 2006 when the Gold Coast Association approached the legislature saying the wall had some problems and needed some repairs. The legislature funded to the tune of $2 million, or set aside $2 million appropriation for the repair of the seawall. And it was at that time that the State Department of Land and Natural Resources, DLNR, took the position that repairing and maintaining the seawall was not the state's responsibility, and it would not go forward with the repairs. That resulted in a declaratory action in the circuit court where the Gold Coast Association sued the state of Hawaii, basically over the ownership and responsibility to maintain and repair the seawall. Interesting procedure, but this is also important. The state filed its own claim. It wasn't a counterclaim. It was its own complaint, also for declaratory ruling that it didn't own the wall and didn't have these responsibilities. That only really has any significance because it came up later in the question about attorney's fees in the case. So I'll get to that. That's not really the most salient point of the case. Let me see. The circuit court held that the state had obtained an easement over the surface of the seawall through the common law doctrine of implied dedication. The circuit court also held that the state owned the fee or the land underneath the seawall by virtue of surrender under Hawaii's property surrender statute, HRS Chapter 264. The Intermediate Court of Appeals affirmed the circuit court. That was appealed by the state of Hawaii to the Hawaii Supreme Court. So the Hawaii Supreme Court affirmed the appellate court and the circuit court, but disagreed with it in some respects. And then, as I said, you had this majority opinion and a dissent. And so we'll go through that. The Hawaii Supreme Court held that the state did obtain an easement across the top of the seawall by virtue of the common law doctrine of implied dedication. And I had to go review Real Property 1 and 2 to figure out what implied dedication was. This case explains it, however, which is under the common law, dedication is accomplished expressly or by deed, expressly by deed or impliedly by acts and conduct which manifest an intent to give the property for public use. And under the common law, formal acceptance by the government is not required to effectuate an implied dedication. Acceptance by the government can be inferred from continuous public use. And the Supreme Court has also taught us with this decision that so these are all restatements of the Hawaii Supreme Court nowadays over what the law of implied dedication is. And if public use is the only evidence of dedication to public use, then it must continue for longer than the prescriptive easement period or longer than adverse possession, 20 years. And the court also pointed out that implied dedication can arise from certain government actions like maintenance of an area or providing beach patrols or utility connections. So the argument of the state or the DLNR on this appeal was that the common law of implied dedication in Hawaii had been abrogated by statutory law, mainly or primarily Chapter 264, the surrender statute. The Hawaii Supreme Court, the majority opinion, said that, and it goes back to HRS 1-1 that says Hawaii adopts the common law of the courts of England and the United States, except as otherwise provided by statute. And the court said that that requires an express statutory abrogation of common law principles. It looked at Chapter 264 and said that while that set up a regime for the dedication of property to the public, it was not the only one. And so therefore, it coexisted along with the common law doctrine of implied dedication. The state of Hawaii pointed to a few other statutes to support that conclusion. There's statutes dealing with the powers of the Attorney General to approve interest in real property. There was the, let's see, so they pointed to HRS Chapter 171, which gave the DLNR responsibility over state lands, including by dedication. They pointed to the AG statutes. They pointed to Chapter 520, which is landowner liability for recreational uses. The Supreme Court said that all of those combined or alone didn't amount to evidence that of abrogation of this common law of implied dedication. Turning to the facts of the case, the court said that the fact that you had continuous public use, you had government assertion of control through its actions and its statements, and that you had no interference with the public use by the private landowners. In other words, the associations that actually own the interest in the seawall. And I should point out, the evidence was that the seawall was built on private property rather than on state property. But the court said that all these actions and this history had indicated that the Gold Coast Association raised the rebuttable presumption of implied dedication to the government and pointed out that the state hadn't introduced any evidence to rebut that presumption. The court said, well, what is the nature of that implied dedication? It said it's effectively an easement over the surface of the seawall, an easement for access. The court did give what the dissent points out to be a problematic ruling, because at the crux of this case was about the financial obligation to repair and maintain the seawall, which, as one can guess, would get expensive. So the Supreme Court said that the state has the right and the duty to maintain the surface of the seawall over and across which it has an easement. It went on to analyze common law, and it said that when you have both the dominant estate and the serving estate owners jointly using an easement, as they acknowledged here, both the public and the private owners or the members of these various condo associations had the right to use it, that there was a joint obligation to repair and maintain. And then the court ended up, so I mean, clearly that raises the question, well, who's going to be responsible to pay for it? The court didn't give much guidance other than saying that that was something a trial court could figure out. But in a case like this, where you had both public and private use of this easement, the obligation to repair and maintain would be joint. This is where the Supreme Court disagreed with the ICA and the Circuit Court, which was both of those courts had held that the land under the seawall was surrendered to the state of Hawaii and became the state of Hawaii's. The court applied that same statute, Chapter 264, on surrender, and said that it had not been effectively surrendered to the state of Hawaii. Let's see, the court, in doing that, looked back to the Kimball versus Levy case that I mentioned, which dealt with another seawall in Waikiki. Mr. Case, I'm not sure if it was fronting an outrigger property or not. I don't remember. I think it might be down by the Sheraton, actually. But the court said that where, let me get this right, a seawall over which the state holds a pre-existing easement for public travel will be deemed to be surrendered to the state if it was opened, laid out, or built by private parties and no active ownership has been exercised by the owner for 5 years, except, of course, if it's land court, the court pointed out. With respect to the Gold Coast seawall, the majority pointed out that there was no pre-existing easement prior to this litigation. There was no pre-existing easement in favor of the state or the public over the top of the seawall, so therefore it didn't qualify for surrender. So the net result was they affirmed the decision on the easement by implied dedication, but the actual ownership of the seawall was not surrendered to the state of Hawaii and remains with the abutting private property owners. There was an attorney's fee issue in that case. The Intermediate Court of Appeals held that the state of, and it was sizable attorney's fees, $364,000 I think that the plaintiffs were seeking. The ICA held that they were entitled to attorney's fees because the state had effectively waived sovereign immunity by filing its own declaratory action, which I believe was consolidated with the original plaintiff's case. The Hawaii Supreme Court, and I'm not going to go into the analysis, but basically said that injunctive and declaratory relief, and they looked at prior cases, doesn't necessarily, it's asking for prospective relief, which therefore doesn't affect a waiver of sovereign immunity. In this case, sovereign immunity wasn't waived by the state. The state wasn't going to be liable for the plaintiff's attorney's fees. Let me turn real quickly to the dissent, which was Justice Nakayama with Rechtenwald concurring. She disagrees that this distinction about a pre-existing easement being determinative over surrender. She said that was kind of artificial and pulled out of some cases, didn't really exist, and she didn't subscribe to that theory. But ultimately, and more importantly, she and Justice Rechtenwald would have held that Chapter 264, the state surrender statute, is an abrogation of common law doctrine of implied dedication, and that statute makes clear that the only way that the state can take title to private property, in this case a trail, and they spent a lot of time talking about is a seawall a public trail, and they agreed that it was for these purposes. But the statute makes clear that the only way that a trail can be surrendered to the public is by a deed of conveyance, which is also then therefore accepted by the state of Hawaii. That manifested the legislature, the adoption of that chapter manifested the legislature's intent to abrogate the common law doctrine of implied dedication, and they would have found that the state didn't have any of those responsibilities. So that's the seawall case. And just a side note, I do a lot of stuff dealing with DLNR, dealing with seawalls and things like that, and I got, after this case came out, a lot of calls. Well, how did, boy, the state of Hawaii really took a hit on this one, right? That must mean that seawalls are legal. One issue that wasn't really an issue in this case was the legality of the seawall to begin with. I mean, I think it was assumed because it was built in the 30s that it existed before current laws would say you can't do that. But that wasn't decided by the Supreme Court. The Supreme Court didn't, in this case, expressly bless the construction of a seawall. I think it does have lots of ramifications, however, for the state around the islands. One of the reasons is what the state has been doing when it comes to pre-existing seawalls, pre-existing revetments that were either built on private property, but by virtue of the movement of the shoreline are now on public property, or ones which were built originally on public property and outside of property lines. The state has in some situations said we will allow that to remain, but you have to obtain an easement from the state of Hawaii allowing it to remain. So many owners have gone and done that, and that raises a question in my mind about whether that is this pre-existing easement for access over the surface of the seawall revetment, which would have triggered this kind of surrender concept, which the Supreme Court didn't buy into in the Gold Coast case. But I don't know, there's a lot of questions yet to be resolved, and that's the Gold Coast case. And I didn't fall off of that seawall. I'll move on and talk about a few other, sorry, looking at the clock in the back, and we're not going to follow the order here, and I wanted to be sure that I hit a couple other important ones, and then I turn it over to Mark so he has sufficient time to talk about several others. The next one I want to talk about is Leong versus County of Maui, which was a unanimous decision issued in October 2017 with Justice Nakayama writing the opinion. And this is an inverse condemnation or a takings claim. And in fact, and Robert, tell me if I'm wrong, my partner Robert Thomas and I have worked on a lot of these over the years, but this might have been the first one that's actually gone both to trial and then up to the Hawaii Supreme Court on an inverse condemnation case in Hawaii. It comes out of Maui. If you're familiar with Maui, down in Wailea and Makena, there's an area called Kalawea Beach, which had 9 small lots, beachfront lots. The County of Maui designated those park under the Kihei Makena Community Plan, saying it would be nice to have a public park down there at last undeveloped beach space on that side of the island. The properties had been zoned resort. And by the way, all these properties were basically, I think, 10 to 12 or 15,000 square feet. They were basically single-family residential sized lots. Maui could only afford at the time to purchase 2 of the lots, which it did, right in the middle of this section of beaches. The Leonis bought their home, or their property, for $3.7 million. Important point is that in aside to the planning, in the community plan being park, and the zoning being resort zoning, and that's under the county statutes, this was also in the SMA, the Special Management Area, which one of the provisions in Chapter 205A says that when granting an SMA permit, the county, it's a state law but delegated to the counties have to make sure that there's consistency between the proposed use and what's authorized under the zoning and under the planning. And that kind of distinction between zoning and planning gave us the Gatry versus Blaine case, also out of Maui, Hawaii Supreme Court case from maybe a decade ago, that said that where those two are inconsistent, the zoning and the planning, they have to be in consistency to get an SMA permit. So the Leonis were the victim of the Gatry decision and the specific language of Chapter 205A. So in 2007, they submitted what's called an SMA assessment in Maui County, where they provided the county their proposed use, and the county will look at it to determine whether it's exempt from the SMA requirements as construction of a single-family residence would be. But in this case, because the county looked at it, the planning director said we can issue an SMA permit because you have inconsistency between the zone and the plan. You have to submit a community plan change application which would redesignate the land from park to some other use that would be consistent with the construction of a single-family residence. Then we could process an SMA. The Leonis filed suit claiming inverse condemnation, saying that basically their property was frozen because of the way the county had zoned it and planned it. They couldn't do anything with it. Filed in the Second Circuit Court. The County of Maui argued that that case should be dismissed because the case wasn't right. And under the arcane language of inverse condemnation and takings, they said you haven't exhausted your remedies. One remedy that you have available to you, which the County of Maui told you, is that you could process a plan amendment and therefore get these into consistency and eventually perhaps get a permit to be able to build a house. The Circuit Court dismissed the case on that basis. That case was appealed, and that is not the Leone that I'm talking about today, but that was appealed to the Intermediate Court of Appeals a few years ago, and the Intermediate Court of Appeals held that that rightness of a case or exhaustion for purposes of a takings claim doesn't require a property owner to seek a legislative change, which a zone change would be legislative, a plan change would be legislative. They basically said if the county has set up a regulatory regime that allows you no use, you don't have to seek to change the law to bring a takings case. Remanded to the Circuit Court, and by the way, that the Hawaii Supreme Court denied cert on that one. So it went back to the Circuit Court for a jury trial on inverse condemnation, and that's the case that we're talking about today. In 2015, the case was presented to the jury on Maui. The jury, I won't explain why because that's more relevant to the appellate opinion, but the jury found for the county, found that there was no taking of the property, and the real issue, if you follow takings, you can have physical takings, you can have regulatory takings. This was a regulatory taking case that claimed that they had been deprived of all economically beneficial use of their property by virtue of the county's regulations and its administrative process. Jury finds for the county, that's appealed. Hawaii Supreme Court decision comes out earlier this year affirming the jury verdict. And I think the important parts, there were a number of issues that were appealed, but the real questions turned on whether they'd been denied all economically viable use, which is what the U.S. Supreme Court tells us in Lucas, that property owners who suffer that have suffered a taking. There was a battle of the appraisers trying to determine highest and best use of the property, value of the property, things like that. And that was one of the issues on appeal. The county's appraiser had testified that a use of property which he considers is investment use, basically buying property, holding it vacant until it appreciates in the future, and then selling it. The Leonis and their experts argued that that was not a use of property. They pointed to not Hawaii Supreme Court cases, U.S. Supreme Court cases and other federal cases that talk about actual use of land, and land that is forced to be kept in its undeveloped state is often indicative of a taking. So that issue comes up to the Hawaii Supreme Court. The Hawaii Supreme Court looks at all those federal cases and the U.S. Supreme Court cases and says, while value of land, or this, basically the appraiser said that if you just held this land vacant, waited for appreciation, sold it to somebody else who might go about running through all these hurdles and developing it, that's a use in and of itself. The Hawaii Supreme Court said that while value like that is not the sole factor, it's never been excluded as a factor that courts consider in a takings case. So it was proper to introduce that evidence at the trial court level, and therefore the jury could have felt that that was a use of the property. Another bit of evidence that came in on cross-examination of the defendant's experts was that within all the uses under the Maui zoning code for resort use, one of those buried in very low on the list was certain commercial uses as supervised by the county. There was a question what that meant, but basically it came into the jury that, well, they could have, the Leonis could have perhaps put a concession stand on that property and rented surfboards or sold food or some other commercial use. The appraisers or the experts were arguing, well, that really says only the county can operate a concession on park property. The Supreme Court seemed to agree, and certainly the jury agreed, that no, that wasn't limited to a county park, but it could be a privately planned park parcel. So they said there was some evidence of some other economically viable use of the land other than as a single-family residence, and therefore they affirmed the jury verdict. There was some appeal issues dealt with various jury instructions about this, and the court basically found that there wasn't any error by the circuit court in giving those jury instructions. So it upheld the verdict in favor of the County of Maui, certainly emboldening the County of Maui. I'm not sure if any of you are out there, but I've talked to a few court counsel over there, and they like this decision. I don't know what the takeaway is, other than I don't think that you would want to get a Maui jury to decide rights on a beachfront lot, which you purchased for $3.7 million, which your expert claimed was worth $19 million, and for which you sought $50 million in punitive damages, and maybe expect that Maui County taxpayers aren't going to hesitate in awarding those damages. So, but there's a lot of interesting lessons about the evidence that goes in, the expert opinions, and so forth. So it's an interesting case for those reasons, and certainly it also shows Hawaii Supreme Court's interpretation of a variety of federal, U.S. Supreme Court and lower court cases on inverse condemnation damages and the like. How am I doing?
Okay.
5 minutes or less. There's the one other case I want to, oh, no, this will be a good one. This is a reported decision, but it's pretty narrow in its application. That's the case on the handout called Scholes versus Kawaguchi, September 27 ICA opinion that will be a published opinion. That case dealt with the jurisdictional split between the district courts and the circuit courts when it comes to title of real property in a summary possession or ejectment action. And in that case, the long and short of it was the parents owned property that had been in the land, that has been land courted. So the land court system applies. At some point in the 90s, they put their son on the deed with them as joint tenants. They then told their son, and I don't think he was a young son. He had lived on the property for 30 years and improved it, never paid rent. In the 90s, the parents said, we want to move to Vegas. No, maybe it was the 2000s. We need to buy a house. Let's transfer the deed back to us directly so that we can obtain a loan on the property, buy a house in Vegas, and then all these supposed promises about, yeah, you'll inherit it at some point, you'll get it, remain out there. Parents, for whatever reason, obviously there's a breakdown in the family relationship, filed an ejectment suit against the son in 2015, claiming they owned the property, he had no right to be there. That was the district court case that was filed. Son defended the district court case by saying, I'm suing my parents in the circuit court over title to the property. They made me promises, I relied on those promises, they defrauded me. And because title's at issue, that should deprive the district court of jurisdiction over what would otherwise be a district court case, and it should be decided in the circuit court. District court disagreed with that, said a transfer certificate of title on land courted property is conclusive as to ownership. Son, you're not on the TCT, you're out of luck. Judgment for parents, writ of possession issue, judgment for possession issue, end of case. That case is appealed. The ICA looked at it, and I guess all that really matters, especially for those of us that deal with land court property and the guarantees that come with it, is the ICA said there's an old Hawaii Supreme Court case from 2005 called Ames that points out certain exceptions to that for fraud. And in fact, there's really 3 exceptions to a TCT for fraud. Fraud in the factum, fraud in the inducement, or the third is constructive fraud. And they looked at the allegations in this case and the affidavits that were submitted to the district court, and they said this raises the question of constructive fraud, which requires fraud by people that are in a fiduciary or confidential relationship. They said son said he was in a confidential relationship with his parents. Son also said that he was questioning whether there was a forgery on the deed that went from he and his parents to just his parents. And so that forgery also raised the question of fraud. Therefore, the ICA held that he had sufficiently raised the question of fraud, which would get around the TCT, which put title just in the parents, and therefore, because title to the real estate was at issue in the district court case, the district court didn't have jurisdiction, and so the case should have been dismissed from the circuit court and allowed to be resolved where title issues are resolved, which is in the circuit court. Update on the telescope cases. So if you've been living in that big tent up on Mauna Loa or somewhere for the last 8 months or 10 months or however long they had those astronaut people living there and not getting any outside news, you wouldn't know any of this. Otherwise, most of us have followed in the newspapers what's happened with the telescope, the TMT case. In a nutshell, we talked about this a few years ago, the Supreme Court decision that held that the BLNR had violated due process with its procedure of granting a permit before granting a contested case hearing on that permit. The case was remanded to the land board, which appointed retired Judge Ricky Mayamano as hearings officer to conduct a new contested case hearing, which was in the papers and dragging on for months and months this past year. Judge Amano came out with her findings and recommendations recommending that a CDUA permit, because The 30-meter telescope is at the top of Mauna Kea and will be, located in the conservation district. So the only way to build a telescope is a CDUA permit for conservation district uses. She recommended granting that. That went to the land board just a few months ago, which is what the procedure on a contested case hearing done before a hearings officer is before that agency or any others. The hearings officer makes the recommendations after hearing the evidence, and then that goes to the agency to be adopted, rejected, modified. The land board ended up agreeing that a CDUA permit should issue on a 5-2 vote, very controversial. That case is now going to be appealed to the Hawaii Supreme Court. Hawaii, which is one of the legislative changes that impact a lot of us practitioners. The legislature last year adopted Act 48, which said that on certain agency appeals, there is a direct appeal from the agency that did the contested case hearing. Land Use Commission, CWRM, Conservation District issues before the Land Board, Public Utilities Commission. Direct appeal from that decision by the agency to the Hawaii Supreme Court. So you bypass the normal procedure in a Chapter 91 case, which is it comes up to the circuit court for appellate review. From there, somebody wants to appeal, it goes to the ICA unless the Supreme Court takes it. Legislature has said there's this direct appeal. That case will be one that's on the direct appeal. But that's not all about telescopes, because at the same time we had the ASTA telescope, which is a solar telescope on Haleakala, proceeding up through similar challenges. The Hawaii Supreme Court came out with 2 decisions about the Haleakala telescope case in October 2016. So we talked about these last year. I'm not really going to cover them other than to how they kind of inform administrative procedure and what the Supreme Court might or might not do with the TMT appeal, which is going up. By the way, the TMT appeal is also going up on a second issue, which was the opponents of the telescope challenged a sublease that was issued by DLNR in the state of Hawaii to University of Hawaii for the TMT site. Their claim was that we should have gotten a contested case hearing on the issuance of a sublease. BLNR said no. Third Circuit Court as an administrative appeal said, yeah, you should have granted a contested case hearing. That's also on appeal to the Hawaii Supreme Court, and the parties are all the same in both of these things, the substantive CDUA permit as well as the sublease. And I don't know if they've been consolidated on appeal, but the Hawaii Supreme Court is going to decide those both on this kind of expedited appeal process which the legislature created. Back to Haleakala. These 2 decisions, one of them had some interesting ramifications for discovery in a Chapter 343 environmental assessment, environmental impact statement case, and we've talked about those before. The other one, which I think is instructive for those of us that like to guess what the Supreme Court will do, did decide the merits of the Haleakala CDUA permit. And by the way, it's interesting reading because there was a host of challenges about ex parte communications with a hearings officer, appearance of impropriety, all the kind of challenges that you would have, which the Supreme Court resolved basically in favor of the process in that Haleakala telescope case. They said that the strange things that went on, and some of you may remember that the first hearings officer had been pressured by a governor and a U.S. senator to come out with a decision. He recused himself. They appointed a new hearings officer. He conducted the hearings. So it was an interesting case. The Supreme Court said, okay, they cured all those procedural defects. And looking at the merits under the applicable regulations for a CDUA permit for a telescope, the BLNR didn't make mistakes, and the telescope, subject to the conditions that were imposed, met the conservation district use requirements. So it was a valid and approved permit for conservation district. That's Haleakala. Obviously different set of facts and other claims being made in Mauna Kea TMT case, but a lot of similarities. And I was always of the opinion that if the land board was ever able to overcome huge procedural defects that their process previously had allowed. And if these ever got to the merits to the Hawaii Supreme Court, it would be a different result. And I think that was vindicated in the Haleakala case, and that's maybe speculation for what they'll do with the TMT case. But we should probably know that. Well, it's got to be briefed and argued, but you know, in the next year, we'll probably be talking about that next year if I'm invited back.
Which is a big if, because you've already taken 45 minutes.
Well, there was 15 minutes was the introduction.
That's true.
And your caveats.
In my defense, as we're walking over here, I told Greg, I had a real tough morning, so why don't you go first? And as I was scanning over the outline of the handout that we provided, I realized that I had intended to alphabetize it, and I didn't alphabetize it. And so if any of you struggle with things and you're trying to figure out what pattern or order it is, this was the order that I put this into my email inbox, and it is actually not even the dates. It's not even chronological, so don't try. It's only 12 things. No. Briefly, so I'm only 48, and so about the only thing I know about co-ops is I can spell it. There are some of these out there, and we actually, the ICA had a co-op decision come out this year. It's the Kugle Eptide. It's about 5 pages long. It's memo op. There's not a lot of law there, but if you practice in co-ops, they are a different animal, and so the traditional arguments that you make in real estate litigation, statute of frauds, land court, etc., don't necessarily apply. So I don't know how many co-ops there actually are in Hawaii, 10, 20, but look at Kugle Eptide if you have one of them. The next case I wanted to mention, the next two cases relate to non-judicial foreclosure. The Hivalani case is an ICA decision, but the Hungate versus Rosen is from the Supreme Court. In Hungate versus Rosen, now this was a Part 1 non-judicial foreclosure for property on Kauai, and there was after the downturn, the Lehman Brothers collapse, etc. There were a lot of non-judicial foreclosures that took place in Hawaii. Some from lenders, especially mainland banks. Some from homeowner association. The homeowner association non-judicial foreclosures have triggered a class action and so several lawsuits against the law firms that conducted them, as well as the AOAOs. No reported decisions as of yet, and so I'm not going to talk about that aspect. The Hungate case went up where a non-judicial foreclosure auction was held, but after the original notice of intent to invoke the mortgagee's power of sale and auction the property off with a specific date for the auction was postponed several times, and the new auction date wasn't advertised and published. So after the lender did a credit bid, acquired the property at the non-judicial foreclosure for less than fair market value. Afterwards, the landowner brought a suit against the attorney who conducted the non-judicial foreclosure, as well as the lender. They challenged the non-judicial foreclosure process as an unfair and deceptive trade practice, or an unfair and deceptive act or practice, saying that they had to strictly comply with the publication requirements of both their power of sale as well as the statute, and they failed to do so. The first published, the first notice of publication was 1 day short. They only gave 29 days, not 30, and the statute said you had to do 30, and so that was a violation. The 3 or 4 postponements was also a violation. But as a former officer of the HSBA, we kind of want to protect the attorneys for when we represent clients and advocate their cases from when we do, and when we should be held personally liable. The Supreme Court found that the landowner did not have a claim against the attorney, that the attorney's obligations and duties were only to the lender in that case. The lender might have culpability for the acts of its agents, but the landowner was not allowed to proceed with a claim against the attorney. So if you do non-judicial foreclosure work, or if you draft powers of sale and mortgages and the like, that's a highly dynamic thing right now, and the legislature's changed the law several times in the last 6 years, and so I think it bears refreshing every year, so that you don't have the situation of attorneys getting sued for these challenges or problems. The next case is the Hivalani Holding versus Wells Fargo Bank case. That's a memo opinion. It was a non-judicial foreclosure, and the problem with that case was the right hand and the left hand didn't know what they were doing. So the collection side of the lender authorized the non-judicial foreclosure and to proceed, while the customer service side was negotiating and trying to do a workout with the borrower. Ultimately, the borrower was approved for a workout, but unfortunately, the property had been sold at auction. It didn't quite. I don't think the deed was conveyed, so the purchaser didn't actually have title yet, and so that went up first to the ICA. It went back down, and then this time the situation was what claim the purchaser at an auction had a breach of contract case, an oral contract or some other type of a recognized contract right against the lender for successfully buying it at auction. And in that case, the ICA said they do have a claim for the contract. There was enough terms, writings, etc. And so it got remanded down for damages, but the ICA did find that the successful bidder at a non-judicial foreclosure auction did have contract rights, even when for a breach of contract, when the actual foreclosure got undone and the landowner got to keep their property. Interesting case. Turning to condemnation, we don't have a whole lot of condemnation law in Hawaii, and the last substantive change to our eminent domain code, HRS Chapter 101, was made in the 50s. And so we have an old code that hasn't caught up with a lot of the newer case law that comes out of the Supreme Court. This is kind of an interesting case related to a frequent party in Hawaii litigation. And it was a condemnation of some land along the Hanalei River. And there were several parcels of land that were taken. And the question becomes, when you only take part of an owner's property, to what level is the owner's remainder property entitled to severance damages? Severance damages are authorized by both the Chapter 101 as well as by the U.S. and Hawaii Constitution. And so in this case, there was the defendant, the condemnation defendant landowner, had some land that was taken, but he also had easement rights in a separate parcel that was not adjacent to the land that was taken. The ICA came out with a decision last year that I did talk about, where the ICA said, well, the two lots are not contiguous, therefore the property interest that he had in the lot that wasn't taken didn't suffer any severance damages. We thought that that was not in keeping with both Hawaii law as well as national law in how you determine a landowner's damages for damages to the remainder or the larger parcel. It went up to the Supreme Court. My partner Robert Thomas and I submitted an amicus brief attempting to help the Supreme Court understand that the ICA's decision disregarded a prior Hawaii Supreme Court decision and could be very easily read to mean that that Hawaii abandoned the Unities test. And so classically, you measure severance damages, or a landowner can claim severance damages in a condemnation scenario if there's three factors: unity of title, unity of physical unity, and unity of use. And so classically, if a landowner wants to claim has a claim for severance damages, that is measured based on its land holdings. And so title has to be the same or affiliated landowner. It has to be physically proximate to each other, and the uses have to be integrated. Now, what's interesting is everyone from criminal law back in law school, we have elements and we have factors. And so the ICA thought that the Unities test from the prior Hawaii Supreme Court decision in the bonded investments case was a element test. And so this landowner's lots were not physically contiguous, and so the ICA said, you lose. Supreme Court said, no, these aren't elements, these are factors. And there's several decisions on the mainland. One of the ones we cited was, if anyone's familiar with the former Navy bombing range at Vieques Island off the coast of Puerto Rico. There was a landowner that had land on Vieques, and I think it's 3-4 miles? 17 miles off the coast of Puerto Rico, where he also had land, and he used the two lands in conjunction with each other for his agricultural thing.
Sugar plantation.
And the First Circuit Court of Appeals said, physical continuity is not the requirement of this Unities test, it's unity of use. The landowner in that case used the properties together and was entitled to severance damages when the Navy took the Vieques property. So that is interesting condemnation case that we don't always get. It's very noteworthy because the City and County of Honolulu is embarking on perhaps the biggest partial condemnation project in state history. Classically, when we have these larger public improvement projects, H3, expansion of the airport, H1, we have Liki Liki Highway. That's when we get these condemnation cases pop up through the courts. And so the current rail project is mostly government land and strip takings or partial takings. And so this is an important decision that establishes that test for severance damages. I want to next talk briefly about the Onaga case. I don't see any real foreclosure practitioners in here. The Hawaii Supreme Court came out with a decision in the Bank of New York Mellon versus Onaga case. That was a judicial foreclosure, and in that situation, there were two mortgagees, and the case went into foreclosure. It was sold at auction, and an appeal was taken from the order confirming the sale to the successful buyer. The appellant, or I think it was the second mortgagee, didn't post a bond and seek a stay of the order confirming sale. And so while it was up on appeal, the sale went through, and the property was conveyed to the buyer at auction. And so the Supreme Court said that, look, we can't give you the remedy that you want. Your case is moot. If you want to stop a foreclosure, a successful purchaser at an auction from taking place, you have to seek a stay from the trial court. And absent that, your case will be mooted. You can get a righteous claim. The final case I think we'll have time to talk about is a environmental Chapter 343 case called Umberger versus DLNR. And Civil Beat has had several articles about this case, and so I don't want to do anything but give you kind of a broad brush overview that in 73 pages, the Hawaii Supreme Court read into the Chapter 343, which is the Hawaii Environmental Policy Act. And the Hawaii Environmental Policy Act is designed to force governmental agencies to understand or assess or at least capture the environmental impacts of their permitting actions, whatever permitting actions they may be, land, water, resource, zoning, whatever. And the Chapter 343 has a lot of fluffy language about what the aims of its the statutory aims are. Justice Pollack in this Umberger case cites to a lot of that, and Umberger related to DLNR's permitting for aquarium collection, fish for aquariums. The two types of permits that went up were the commercial ones and the recreational ones. And DLNR's process was you log on the computer, click, 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 pay $10 or $30, whatever it was, and you get the permit. And it allows you to take up to X amount of fish by species. I think this case came out last year and we did talk about it, but the ICA thought that an environmental group challenged that permitting process and said, before DLNR should issue any of those permits, the applicant or DLNR should be forced to do an environmental assessment at least to determine if there is a significant environmental impact, which would trigger an EIS. I think the ICA decision was thought that, look, there's hundreds of these permits to go through. This could just be grandpa going out with a scoop net and scooping up 2 fish for their grandchild's goldfish bowl. that is not Mark's hypo. It was in the ICA decision, and so there's just no way. It would just slow things down. Environmental assessment is a 6, 8, 10-week process, 25, 30 grand, and I think it was just like there's no way that the ICA's position was that there's no way the ledge could have intended that an EA should be required for each of these permits. The environmental group lost and then appealed to the Supreme Court, and the Supreme Court disagreed. And they went the other way on the hypo, saying that under each of these permits, I think that's 2,200 fish per year could be taken, and degradation of the reef, and impacts on the reef, and coral, etc. And so they said that the LNR can issue no more commercial permits until they do environmental assessment. I don't recall whether they actually got down to whether they could do a programmatic environmental assessment, which is something that is done. You see it on the federal side. You see the Sierra Club case, I think, involved a programmatic environmental assessment on tourism. But so I don't recall whether that. I'm sure DLNR hopes that they can do just a programmatic assessment and not a permit by permit one. The recreational aspect of it, Justice Pollock was not the Grinch that stole away goldfish bowls. He found that the taking of 1 or 2 fish might be such a minor activity that it was exempted under the statutory and regulatory exemptions that DLNR had approved, and so remanded the case back to the circuit court for a decision on what the actual recreational permit, whether that should be categorically excluded or barred as well. Something happened in the last month or so, and if anyone knows, with that case, because there was a writ of mandamus denied by the Hawaii Supreme Court this week, and so I just had to have a chance to read it before the thing, but that recreational aspect of it is coming back up. But so I think the lesson for practitioners is that if a discretionary permit, which is the requirement, if you're getting a discretionary permit, you need to make sure that, and that's the lesson from Super Ferry too, that you have a statutory exemption from doing the EA or a regulatory exemption, and the Supreme Court will read the exemptions very narrowly, and so caution for the advice you give to your clients about that. I think we're at 1 o'clock. The other kind of highlight things that I included in the material, there was a kerfuffle earlier this year about heirs property, and because a very wealthy and prominent landowner brought heirs property partition actions, and there was some upset about that. It's interesting, the heirs property statute is only about 1.5 years old in Hawaii, and as a property rights attorney, there's actually a good thing for property rights. Heirs property on the mainland is classically talked about in terms of post-Reconstruction era former slaves who owned property, and then sharecroppers and the like, and their estates never get probated, and the property conveyed out of great-grandpa's name. And so you end up in modern day with hundreds of folks with potential tenant in common interests. And so the heirs property gives a statutory regime that facilitates cleaning up the title. And my comment about the Gold Coast case is implied or unwritten stuff or unwritten interest in real estate is very problematic. And we like title reports, and we like to get insurance for those title reports, and we like things to be recorded at the Bureau of Conveyances and Land Court. And when you have implied things relating to land, it's really problematic. And so it's interesting the dialogue that took place in the legislature after the heirs properties lawsuits were filed and then dropped, but and the ledge ultimately decided not to change the partition or the heirs property statute, which I think would be a mistake. But I expect it to come up as a legislative issue in the future. Finally, just to close out real quickly, last year was a very big deal in the United States Supreme Court in the regulatory takings context. And Greg already talked about inverse condemnation and those types of cases in the Leong case. But the Hawaii Supreme Court had an opportunity to clear the air a little and help define, clear up some aspects of regulatory takings and the extent that using some principles from the condemnation law where you have physical acquisition of property. The case is Murr versus Wisconsin, M-U-R-R. Unfortunately for the property rights bar, the Supreme Court didn't clear the air too much, and it is a very complicated decision that will that is kind of upending this area of the law. And so, in that case, a riverfront owner in the state of Wisconsin, they own this family owned 2 lots, one in their own name, and one was entitled in a plumbing company that the mom and dad owned. Ultimately, they passed down as part of their estate plan the properties to their children, but instead of just assigning the stock to the kids, they actually conveyed it from the plumbing company to the kids' names, and so the 2 parcels were owned by in the children's names. There was a quirk of there was some riverfront protection statute and ordinance that said that when you have 2 commonly owned properties owned by the same landowner, they merge for the purposes of you can only build 1 house on the commonly owned property. So if they were owned by 2 different people, you could each have a house, but because they were owned by the same people, you can only build 1 house. They took that up to the Supreme Court, and the Supreme Court found that no, it was a valid operation of Wisconsin's merger law, and it's kind of problematic. The Supreme Court in probably 15 years ago came out with a decision called Palazzolo, arising from Rhode Island, and we tend to think of property as bundles of sticks, and what I give to you and can sell to Greg, it shouldn't matter that I am me and Greg is Greg. It's the bundle of sticks that matters. And in Palazzolo, where you had a situation of a buyer buying property after an ordinance was passed or a state law was passed that was likely a regulatory taking, the question was whether the new buyer who bought the property with full knowledge of the law could bring the inverse condemnation claim. And in that case, the Supreme Court said for sure that the inverse condemnation claim, the claim against the offending regulation was one of the bundles of sticks that the buyer bought. And so this one kind of upended that. Anyway, my final point, we talked about the Arkansas Game and Fish case probably about 3, maybe 5 years ago, which was a case where the United States Supreme Court recognized that periodic flooding caused by a government flood control project where they intentionally released water and it flooded out some land that was owned by the Arkansas Fish and Game Commission, and then it was damaging the timber that they were harvesting on there, constituted temporary takings that were recognized under the Fifth Amendment. Some of the governmental planner types posed this hypothetical, or they raised, I think it was an Amicus brief, that you're opening up a host of potential claims against the governments because there's a lot of these governmental actions that they do to protect the broader good. And Justice Ginsburg authored a unanimous decision and kind of said, we'll deal with that when we get to that. Well, this year we have in Houston, there was a reservoir that they released water, and to save the dam or save the project and avoid a different flood, they flooded out people. And so there's been a spate of inverse condemnation claims brought against the federal government of Houston. The California wildfires a couple weeks ago, I think that I saw it mentioned that there was some utility aspect of it, that there's a potential to have those types of claims as well. And so stand by for that. Anyway, I think we're way over time. And I did want to offer up one last thing. Both Robert, Greg, and I, and partners at our law firm, tend to pride ourselves on keeping up on the law, and we are available for folks that call us with brief questions. I'll do 15 minutes. Greg will probably do 5. Robert will do like 2 hours. So careful you call. Anyway, thank you for giving us this opportunity.
I would add I had two other responsibilities on this handout, which were 2 memorandum opinions, Misler and Grande. I didn't talk about them because they're memorandum opinions, but they're interesting reads if you want to follow, especially administrative procedure, which is the Grande versus Ng case. And if you're interested in a Kona community plan, you could look at Misler versus Board of Appeals. But anyway, thank you again, and hopefully we'll have some telescopes to talk about next year. I don't know what else. Maybe aquarium fish, who knows.